Welcome to Health Law Talk, presented by Shahardy Sherman Williams. Health law broken down through expert discussion, real client issues, and real-life experiences. Breaking barriers to understanding complex healthcare issues is our job.
And good afternoon or good morning, whenever you're listening. This is Conrad Meyer on another episode of Health Law Talk, Shahardy Sherman Williams. And in the studio today, we have all of the moderators in today for a group discussion. Rory Bellina, George Mueller in the house. How are you guys?
Doing well. Morning. Happy Friday to everyone.
Yes, this is a Friday.
Absolutely. Great weather here, not in other places, so we're grateful for that.
Amen. Amen. It is. It's beautiful outside.
Absolutely.
You know, we're referring to as if depending on when this gets published, this is right after Hurricane Ian, which we pray for those in Florida. I mean, we've lived through this in Katrina. It's terrible. So, but we're here in the studio, ready to go and talk about what are we talking about today, guys?
I think we're going to talk about how to close a medical practice, right? And was there another piece that y'all were going to talk about as well?
Closing a medical practice and then wrapping up either closing a practice or dismissing a patient, terminating a physician-patient relationship kind of goes hand in hand sometimes.
Sure. Or terminating a
sometimes
patient
not.
in an active practice if they're unruly or what have you.
Correct.
So, right.
Non-compliant?
That would be a good one, yeah.
We've spent a few episodes talking about how to start a practice, how to get credentialed, billing, all that good stuff, but we haven't ever talked about either dismissing a patient or closing a practice. And I think it's a good topic to get on today. So, Conrad, you want to take us off?
Yeah, sure. I mean, I think, I think all of us have come full circle in this in some point where we've gotten a call on closing a practice. And one of the biggest questions, we can start off with, getting rid of patients, or how do you get rid of patients or advise them, or what's the proper way to do it so that you don't get in trouble or there's no liability issues and so forth. Or just having what just a moment ago, an unruly or non-compliant, or do you want to call it difficult patient, right? And there's specific things you have to do for that. So especially from what the board says here. Have you guys, do y'all have any, I guess, war stories from clients? I mean, with respect to some unruly patients or some issues when you're closing a practice?
Yeah. Go ahead, George.
No, I was going to say it seems like two separate but somewhat related issues. Certainly, from my standpoint, typically I'm dealing with people who may be closing a practice, and the immediate thought comes to mind is, what's the reason they're closing the practice? And it could be that they're being bought out. It could be that they're retiring, or it could be some version of that where they're kind of passing the torch. And all of that in the background, you start thinking about a couple of things. One is continuity of care of the existing patient panel, which is very important. And then depending on whether or not the physician is doing a full exit, continuity of maintenance of medical records. Those two things kind of from backing into what the board wants to see and what other laws require. You're dealing with, again, making sure that nothing happens to harm the patient or the continuity of their care, and then nothing happens to those medical records, which of course have all sorts of privacy obligations attached to them. And then so we find that some of our deal documents have a tendency to build those things in, medical records, maintenance agreements. I'm sure you've all seen them, whereas who's going to pay for them, who's going to sweep the dust off of them, who's going to go get them when a subpoena comes or when a file is requested, and then for how long is that obligation? And I think it go to 6 or 7 years, and sometimes they add a year, or depending on what state you're in or who has the records, et cetera. And so that generally speaking is how we deal with it. But wrapping up a medical practice, it's a big deal, and frankly, I think it's also an emotional thing for a physician. If you've practiced for that 20, 30 years, and you're kind of stepping into your next. One of the things we've noticed is that physicians, it's a big deal for them, right? So outside of that, you've got to deliver some good advice on what to do when they need to do it, and then speaking to the things about continuity of care and making sure you comply with the board and with state laws. is also kind of there.
Yeah, and I think, we tend to see a lot where instead of, closing a practice of physicians retiring, being bought out, selling their practice. So we work into the deal documents what happens with the patient records, the patient notices that go out saying that, you have an option to continue on with, the buying doctor or get your records transferred out somewhere. But in the case of an instance of a doctor that's literally closing the doors, not selling his practice, maybe unexpectedly passes away, that's the situation where you have a little bit more kind of reaction thing to do, work. I've experienced a physician that unexpectedly passed away, very unexpectedly. And the process was, essentially you have to notify the board. They want to know where the records are going to go. So you have to figure out where they're going to go. Are you going to keep them at the clinic for, 30, 60, 90 days, allow patients to come get them or put in their transfer request and then send them off to a storage company where you can contact the storage company for, requesting those records. But I think it's important if you're in that situation to definitely talk with someone because there's some specific things that the board wants to see happen. If you don't have a plan in place, just like with a legal practice, transferring over patient or client files, but same thing in a medical practice. So that's typically what I've seen in the unexpected death of someone.
I guess one thing I want to ask, if either of y'all, and I don't know, just talking here, have you seen situations where what you both describe are something that's very, very controlled, right? You're given the advice, you get enough time to close the practice. Rory, in your situation, even though it was unexpected, you're controlling it, right? What about the call where you get, if you've ever gotten this, George, Rory, Conrad, or whoever, we have a situation here, this clinic or doctor so-and-so it seems to be closed, their patient records in the dumpster. We have a serious situation here.
Is this like the windbreaker people are coming to get them?
Right.
Okay.
So I guess the question, have y'all ever dealt with that? Is that even real? Do you think that actually goes on?
I know that, anecdotally, certainly certain practices have a tendency to draw a little bit more regulatory scrutiny. We speak of pain management and other things, or maybe, high DME type practices where enforcement actions are there. I have been around or involved one that involved kind of a joint enforcement action related to the IRS and the ATF at the same time, and because
wow,
and so
what was that like?
Well, it was interesting to say the least because it was a call. You get it one morning, and the physician actually wasn't there. Something else was going on in that physician's life, and said, "Wow, all the windbreakers showed up this morning and pulled all the records and everything." And I think what you do is you want to advise people to be as compliant and as cooperative as possible, because at that point in time, if you're ever in a heavily regulated practice, non-compliance is highly inadvisable, and it's probably only going to worsen whatever scenario it is you're in. And it could be just surprise inspection of records because of controlled substance prescriptions and whatnot, or it could be something that's more specific to who and how they're operating. Right. And so you don't know that because clients don't always tell the truth. Right. So you've got to kind of piece through, while at the same time, I think, advise them not to do anything to worsen any non-compliance that they may have committed or have done. Right.
No, Henry, what about and I get that of the investigation. I get that. But what about the, closing in the shop at midnight, turning off the lights, and suddenly
just
patients are
pull the plug, they got on a boat and yet went to Central America.
Correct. And all of a sudden you see the dumpster filled with stuff, and then it happens to be patient records.
I don't know. We've certainly heard of at other places, tax returns being thrown in the dumpster and whatnot, different things. Depending on who you represent, what your scope of representation is, I don't know what you can do to kind of sua sponte try to mitigate, right? Is that your charge? Are you capable of doing that? Or do you just have to try to get the next best level of information with respect to authority as to who's operating that practice and what's happened? Rory?
Yeah, I've had two instances where something similar has happened. One where a building was being demolished, and in the demolition they found patient records, and someone found that. And of course, instead of contacting the company demolishing or the owner, they call the news and say, I found these patient records. So we had to deal with that. And then the other one was a kind of closing a medical practice or terminating someone. I think this comes up a lot if a provider is unexpectedly terminated. Is there was a provider who was taking home paper medical records and would not return them, and the practice wasn't really sure what records they had and didn't have because they were all on paper, and he had physical paper files at his house. So that process was really, really interesting. It involves contacting the Office of Civil Rights and essentially saying, we have a data breach. We don't know exactly how many patient records were sent home, but we think we know. And there's a process involved. They assign an investigator. You have to answer questions. In this instance, we thought it was below a threshold that they set of 500 more or less. And so basically we had to send out letters to every patient in their billing system, because that's the only way we really knew, saying, hey, we think your records may have been compromised, so call this number if anything happens. We'll sign you up for credit monitoring for a year and pay for it. I mean, the Office of Civil Rights has a whole process. In that case, we self-reported, we mitigated, we did everything that we could to get those records back. They didn't administer a fine against the practice for that. They said, you've done everything correctly, but it could happen. And I think it happens a lot when you've got a doctor that's fired, a doctor that just kind of goes rogue. Maybe they're stealing the files and they're going to go open up their own shop down the street. So those are all real life scenarios that have actually played out.
So what about bankruptcy? I mean, so in other words, like in the case of just close the shop, right? Into the scenario that you described, which is kind of what I'm driving at, is when you have a situation where you just have these derelict patient records, these physical records, right?
They've been orphaned.
Right. And suddenly you have an obligation. Let's say that it happened within the last 7 years, which was still within the statute, right? Who's gonna? First off, where do they go?
Yeah.
And if they get, do they go to a storage? And who is sort of the record supervisor? And who pays for that?
It's funny you mentioned bankruptcy. Right out of law school, I worked at a firm that did a lot of bankruptcy work, and we had a trustee in the office, and there was actually a medical practice involved in a bankruptcy. And it ultimately became the custody of the trustee. And so he didn't have the paper files in his office. They were offsite at storage. But if a patient wanted them, they had to go through him to go through the process.
Even if there's no money left in the kitty to pay for that?
Yeah. I mean, because the trustee gets money from the court that essentially gets, billed to the debtor in that case. But, yeah.
Right.
Yeah.
Interesting.
So it's that trustee's job to administer and manage the assets, which include the records.
Well, guys, what about cloud? I mean, now, right? I mean, most of the time, most practices like are on Athena or some sort of other EHR. Athena, not really an EHR, but some sort of an EHR. So how would, let's just say, just like we talk about losing the records or turning the lights off, what happens if suddenly you close the practice and you lose access to the cloud?
Yeah, I was going to say it's a matter of access, right? And then who has the ability to get that, and is it a function of, well, you haven't paid, so everything's still locked up in the cloud when
you're not an authorized user,
yeah,
right? I mean, come on.
And certainly a patient's not going to be an authorized user for that purpose, right?
And I see that in pretty much every data agreement or EHR agreement that I review. It always talks about, if you terminate or if you're terminated or if this contract just ends, you switch to another vendor. They'll give you
There's some portability
yes
built into that, right?
And the government has stepped in and kind of said that these records need to be able to transfer from one to another and not have a special algorithm or code that prohibits that. But it's still very burdensome to do. And a lot of times these EHR companies will give you a super small window of, you have 10 days to let us know if you want your records. And if you do, it'll be $1 per megabyte, and if you don't, they're destroyed and they're gone forever. And so that's always something that we have to push back on and negotiate and say, hold on a second, if we're closing a practice, we've got 100 things going on.
Yeah,
One of them,
that window is completely insufficient to satisfy the spirit and substance.
That's a short fuse.
And to get those records before they're destroyed, and you want your new IT vendor or wherever you're sending them to be able to look and see, okay, I can access these or I can't, because a lot of times they really don't work with other systems.
Speak to each other, right?
Correct.
Sure. I think, I was thinking one issue that came to mind while Rory was talking about his earlier issue. One thing, the thing that I was involved in prior to I was discussing anecdotally was the IRS, and the DEA, not the ATF. It was a separate set of alphabet soup, but that was it. Is insurance and tail coverage.
I can't keep. Oh, that is a good point.
Yeah.
That's a huge
point on the closing.
and obviously state to state it varies, but I know in Louisiana, and Conrad, you can speak to this better than me, but the manner in which coverage is maintained and the manner in which, and the timing and the time period for which you advise a physician or a practice that they need to continue to maintain that, and they start using the T word, tail coverage, and how long, how much does it cost, and what are they going to do? And that, are they truly sunsetting their practice? Are they moving to a different model where, say, it's an out-of-state private equity company that has all their own insurance? What happens to that local insurance? And then, is the quality of that insurance the same, right? Or do they have access to the same Learned Louisiana Council that your local insurer does, right? I mean, we had talked about that earlier with the local insurer.
And that's important to look at from the beginning, because a lot of times when you're buying your malpractice, you're not paying attention. You want the cheapest plan. So are you going to go occurrence-based, claims made? But then when you go to close, you find out, well, hold on, now I have to buy a tail policy for all this, and they catch you on the back end. I know, Conrad, you've gone through that, and we always get the question, so maybe you could explain to the people listening the difference between claims made or an occurrence-based policy and how tail kicks into that.
Well, I think it's interesting. So tail, the whole purpose of tail is to cover the time period that you were previously employed or with a group. And in Louisiana, it's really interesting because Louisiana has a 3-year preemptive period. Not preemptive. That's it right. So that means that means is there's a maximum of 3 years that a patient can bring a claim against a medical provider, but only 1 year. 1 year from the date of discovery. Maximum of 3 years on the preemptive period.
But where's that 3 years measured from?
Measured from the time the services are rendered.
Does the last time the last patient visit they had, or is it because I always get a little foggy about when does the preemptive, because obviously counsel who might want to keep a claim alive or say that they're within the time period is going to argue that the last touch or the last word or the last advice or the last reliance was
interestingly, you say that. I had a
okay.
case about this. This is very interesting. So doctor did surgery back in 2017. Let's just say it was January 1st, 2017. Okay, so technically the surgery, the encounter was the surgery. The patient knew that there was a problem almost maybe a year after that. They had some complications but never brought suit. Okay? So the clock started from when the patient reasonably would have known that there was an issue from the surgery. So it's a reasonable standard, right? And so you got it. And so they should have brought suit within that year because they're within the three-year time frame, but they didn't. And in fact, they didn't wait to bring the claim until 2021. Which was interesting. So I'm like, well, wait a minute. Something's not. I didn't pass the smell test, right? So I went back and looked at the medical records, and sure enough, what the patient did, I think that they knew that it was wrong. Like, in other words, they knew the claim had prescribed. So because they found out about it, that the surgery was January 1st, 2017. They discovered it January 1st, let's say 2018. So they had 1 year, January 1st, 2019, to file the lawsuit. Well, in the fall of 2019, the patient scheduled a clinic visit with the doctor to discuss the surgery. Nothing else. No other services were brought, just to discuss. And during that meeting, it got very heated. It was documented in the record, and the physician terminated the patient, which we're going to go into a little more. But they try to use that date in the 21st December of 2021. To say that it tripped the 3-year preemptive. That was the date that actually services run, and they lost. I mean, we brought that up to the court. The court obviously agreed with us, and it was prescribed. It was done. So people try to do that. So that's the gray area, and why tail's so important. Tail covers you if you don't have. I always get claims made in occurrence base. I always get those mixed up sometimes. So, but anyway, if you have claims made, covers you for the time I think I just can't recall. I get this confused.
Sorry, Rory's going to remind you.
Rory's going to remind me all that stuff. But anyway, the point is if you need tail coverage, if you think if you have maybe it's occurrence based, that you need tail coverage for the 3 years. Either
I can
way.
hear all the other attorneys are shouting. In
They
the
are like,
speakers.
Conrad, say it right, and I'm just like, wait, it's a Friday. So anyway, the point is the tail coverage is very expensive, and in any employment contract, it's sort of the gotcha moment where we try to negotiate that to make sure that your employee doesn't pay that if they don't have to, depending on who you represent. So. That's the best explanation I can give a tail.
Yeah. So, like
Rory's looking at me right now. He's like, "I got it, Conrad. I got you."
No. So you're on the right path. No, claims made is the policy where you're going to have to buy tail. So it's typically it's cheaper on the front end.
Yeah, right. You swap the economic burden.
Correct.
So I was wrong. So actually, it is claims made. So thank you for correcting me.
Yeah. No problem.
I would have failed the bar exam on that.
It gets confusing. Occurrence is based on its coverage occurring during the term, regardless of when the actual claim is made.
Okay,
claims
so that's
made is when the claim is made, which makes tail very important in that case. So no, that's no problem at all.
That's okay.
But yeah, bringing that back
I'm
to.
glad Rory was here. He got that.
I'm glad I brought the issue up.
You did, because it made me look really kind of foolish.
It's not the point. It was an opportunity to freshen, refresh, and sharpen your knowledge on that.
Good teaching point.
Bringing it back to closing a practice or terminating that patient, your insurance is an important part to find out what you want to do, because like you mentioned, Conrad, you don't want to close the door and cancel it, turn off all the lights, cancel all your utilities, cancel your insurance, and then catch something a year or two later, or get
you don't want that.
And it speaks to, again, I've got dual track going on. One part of me wants to ask, what sort of form letter and what sort of criteria do you have to document in your notes, in your prior visits, in order to be able to quote unquote terminate a patient for the type of willful noncompliance and or something? And then my other thought is, to the point about not wanting to pull the plug, you also just don't want to get rid of that entity that you have, right? Because that's your shield. And so a lot of people want to pull the plug on it immediately.
That's important. I think that's important to talk about, because I have had that phone call where you're shutting down the shop and they're like, okay, I want you to cancel the policies and can you dissolve my entity? And that's when I know, George, you've got the expertise on that to talk about why to not dissolve an entity for a while and the benefits of not doing it.
Yeah, so I think generally speaking, it applies to just about any business, but certainly in one where potential exposure and liability, really does exist. Is that entity, and I realize to a certain degree for medical malpractice that is, you can't really use an entity to shield a professional from that. We know that is embodied in Louisiana law. But for all other types of liability that could be entity specific, you don't want to expose yourself to that personally. And we're talking about tort liability, slip and fall liability. I mean, technically, you can get sued for a breach of contract, I think 10 years in Louisiana, which is almost seems like 10 years. Goodness, that's crazy.
Sure.
We tell people 1 to 3 years and you're pretty much done for everything. But there are some things that have 4-year and 6-year prescriptive periods. Contracts have 10 years. I think practically speaking, you can deal with the allocation of risk and likelihood of exposure and get it to the point where it's remote to non-existent. When you get past 3 years, you can really kind of advise a client. But telling them that they're going to have to pay the Secretary of State 3 more years of fees and file 3 more years of, no activity tax returns, et cetera, it becomes a little, they don't like that. So they want to pull the plug mentally, just want to get it all done.
Right.
But you have to remind people this is almost like an insurance policy in itself. You want to keep that open so that if you had a slip and fall or you had an employment claim that you didn't know about because there was a hostile work environment issue you had no clue about, any of these things, they could be kind of rats in the woodpile waiting to start smelling. And so we try to assess that. And as a practical matter, you do get emails from people. So I just want to get rid of this LLC. It's all fine. I don't have anything. You have some minimums. As an attorney, you have to document. Are you sure you don't have any liabilities, any unperformed contracts, any employees or any things that are coming back to haunt you? You get rid of this, and you could arguably be liable personally, at least to the extent you got money from the LLC, which I think is what the LLC law says. But as a practical matter, you're there without the shield of a limited liability company or corporation to protect you.
And Conrad, what are your thoughts on that from a payer perspective of not wrapping up your LLC, not essentially terminating your NPI from a recoupment standpoint? Yeah.
You're in a quagmire. I mean, you're in a real, first off, you're going to have time to continue to have your receivables come in. I mean, you're lucky if you're between, 30 and 60 days. I mean, that's pretty good.
That's really good.
I mean, that's excellent.
Really
so let's just, you're not likely in that window, if you're even 80 or 90 days out, so that's 3 months. And then you pretty much get all the stragglers in at 120 days, but then you have appeals. So you got to appeal. You might have a lot of appeals. So depending on your current AR, you're going to want to make sure to at least hold open that so you don't lose the opportunity to appeal or recoup, refund, all those issues.
What about Medicare and Medicaid heavy practices that have kind of that annual sort of true up and refund process? I mean, you really have to, I think, let the air fly out of the balloon for a while, right?
And I always advise the same thing, especially patient populations that are heavy on Medicare is, don't wipe the bank account yet. Hold some money in there because there could be a recoupment. They could just funnel it back. And if that bank account's empty or if that entity's gone, I know, George, this has come up on a couple of deals that we're worked on. Everyone wants to sweep that bank account in. I'm closing the practice. I'm moving it over to my personal account. What are your thoughts on that?
I think you got to build in your time and you got to build in some money there. Much the same as we're always chasing a working capital adjustment and how much is enough to leave in. I think when you have these government payers and/or now people are switching to value-based arrangements, and most of them are upside only. I think eventually they're going to be moving to downside, which is going to be another way of just kind of putting recoupment into all the payer deals.
I hate that word.
Sure.
In a healthcare setting, the recoup.
Yeah.
So Conrad, you've done some RAC audit work before.
Yeah.
And how long after, say, the payment event can those come up? Because I think that's another point where you start to look at what is the outside limit of time, and then how can we move that time inward to get the entity done?
I think the look back, I want to say, y'all are getting me terrible today. I think the look back is, I want to say at least, 3 years or 2?
Yeah,
I can't.
The point is every time I think we think about something that is an anecdote that we talked about, our practice point, we find another reason to say, please don't pull the plug yet.
Sure.
And if you've just done a deal, you've probably got at least 18 months to 2 or 3 years on some reps and warranties.
That's arguing the holdback, though, guys. It's arguing the holdback. And how much? Because nobody wants to do that.
Yeah, no, that's certainly a deal point. Always, how much is the holdback? We have percentages that act as thresholds from a negotiation standpoint to start at, and they usually go up or down. And as we know, if the healthcare regulatory attorneys are turned loose on the last 10 days of the deal, they come up with, we've got to return everything, full disclosure. We've got to double a holdback, and all that. So.
Well, look, I get all that, and because of course, we're here to plant, the traps, right, Rory?
Yeah.
I mean, the traps and the deal.
I think it's important to. There's just so many aspects of opening a practice. Everyone's excited. You're getting out, figuring out and going, and then when you want to close it, you just want to be done with it. You want to be done with it yesterday, and unfortunately, it's not a fast process. There's things to keep it open just for like an employment standpoint. If you've got a disgruntled employee or you didn't pay out all their vacation or, anything like that, those issues can always come up too. So I think it's important to not hurry to close as fast as you want to turn off those lights.
You're not doing yourself any favors by trying to, quote unquote, shut the entity down. And for whatever, like I said, whatever nominal charges you're going to incur over that 2 or 3 year period, it's essential. But your reps and warrants that you make. The entity makes a lot of reps and warranties. The fundamental reps never go away, so that's you're not going to get rid of those. But a lot of the operating warranties, reps and warranties, and maybe even some of the qualitative reps and warranties that you make about some of the assets that are conveyed, and/or lack of liability, et cetera. All of those have a pretty slow burning fuse on them. So the reasons to kind of again argue against the go dark.
Yeah, and what about I know we're pivoting a little bit from closing to the sale of a practice, but if you're selling a practice, how important is it? And I know where the answer is going to be, but how important is it to keep that entity alive for any liabilities that could come? I know we've all had deals where they try to get the individual physicians liable on those schedules and those reps and warrants just as much as the entity. And if we're representing seller, we try to pull that back and say, no, this is a rep and warrant of the company, not of the individuals, but keeping that entity alive for those reasons. If they're withholding money in escrow, what are your thoughts on that?
I think keeping them separate wherever possible is really good. The use of knowledge qualifiers is probably your second best line of defense. And the third best line of defense is to shorten the time period for which they exist and apply post-closing. You'd like to have them kind of be up into and prior, and then you get the issue of when something first discovered. Can you get some anti-sandbagging language in there so that they haven't gotten something that you haven't realized and they come after you after the fact? They already knew about it. They close the deal anyway. We try to get that to kind of balance the allocation of risk there a little bit. But in the sale of a practice where it necessitates a closing, I think we really got to advise people to keep the window open a little longer. Let things. It's more of a glide path and a wind down than it is a shut the door, if you will.
Speaking of winding down, I want to pivot for a second. Let's talk about disgruntled patients, okay? Because part of that too. I mean, we talk about sale of practice and how we transfer records and all that. But what about the call you get from the doctor saying, I have a patient in my waiting room who has, decided they wanted to have a pet, or they little feel good pets. They make them feel good, but they're not really allocated. In other words, they
comfort but not
a comfort
certified,
pet but not certified, right?
Service
or they're just
animal.
ruly, or they just call all the time. Whatever. Pick your disgruntled or complaining patient.
Be careful about pets because people are very sensitive about their comfort pets, and
I'm not.
So we don't
I am not.
offend that
I'm
segment
not
of the
offending that.
crowd.
No, we do not want to do that. No, but pick your whatever patient type of complaint you could think of, and finally the doctor says, I'm done. I want to get rid of the patient.
Sure.
How many of you have dealt with that?
I had that not too long ago, and it was actually in a dental practice with a patient.
Oh, wow.
With a male patient
And
who
you
was.
wouldn't think of that in the dental practice.
Well, in the dental practice,
who wants to go to the dentist?
Nobody wants to go.
I like to go. I've been able to get my teeth clean and everything.
That's one thing, but when they bring the drill out.
this was a male patient who was being inappropriate with the dental hygienist, and
whoa,
yeah,
that's not good.
And it became an issue where no one wanted to work on the patient, and it became an issue of, okay, well, we need to terminate you. And
that almost sounds like criminal behavior.
It was
depending on what the
borderline
manifestation of it is.
Yeah.
You gotta watch that.
Yeah, it was very borderline to that. Yes, but
terrible.
Our client didn't want to have to go that route. They just said, we just want to terminate the patient. And
Well, does the dental board have any guidance on that? Did you have to look to that? Or?
yeah, so the dental board says obviously if you're going to discharge a patient, there should be reasons for it to document it. And we talked with the dental board about being professional with the different hygienists. What really came up was the practice wanted to discharge the patient. They didn't want to make a whole thing about it. So the patient, when he found out he was being discharged, decided to file a complaint against the practice, as well as dispute all his credit card charges that he made at the practice for payment.
No good deed goes unpunished, right?
Yeah.
That's
Yeah.
Wow.
Yeah. But so what became very important, though, in discharging a patient, kind of just like anything else, is documenting it. So this practice, they had the hygienist write a statement. They had the doctor write a statement. He actually had, a lot of things to back that up, and was able to, because when the dental board said, well, what happened, he was saying, well, here's my statement, here's the hygienist's statement, here's what was going on, and that's why we discharged the patient.
And as a practice owner, you have an affirmative duty to provide a safe work
Correct.
environment
Right.
for
Right.
your employee,
Correct.
and to protect them, and to swiftly, quickly, and adequately
Correct.
respond to that. That's a threat, is what
Yeah.
that is. That is it could be apprehension of harm. It's
Sure.
going to be an assault. If there's unwanted touching, that is a battery of a potentially very aggravating nature.
Not a
And
good
so-
situation.
Yeah. No, you've got to.
So it became something where the patient was discharged, received a letter, and was told he can go pick up his records. They'd be there, no charge, and to move on. And the patient eventually did, but was not happy about it.
Now, see, the board the Board of Medicine actually has an advisory opinion directly on this. And so when physicians call, if you ever get this call, you can always point them to the advisory opinion that lays out a literally 6-step process to terminate a patient. And it's got all the things we talk about. It talks about notifying the patient in writing of your intention to dismiss or fire them and give them a specific date. I'm firing you as of this date and give them notice for 30 days.
Okay.
It's upcoming. So in other words, you can say, I'm going to fire you within this 30-day period.
Can you fire them for any reason, or does it list out criteria? So you
could just terminate them if you just don't want to work with them anymore, or whatever the reason is.
Full panel.
There's no enunciate. Doesn't matter. Doesn't matter. Okay. You got to provide but you have to give an explanation of why. So it doesn't say
it can be any reason, but you better
tell why, right? And so that way, if they make a complaint to the board, they can understand why, and they can show them the reason. Mm-hmm. Document the notification in the medical record. That's very important. You might have the letter, right? You write in a file.
You need a note with a date,
but you need to put it make it part of the record, right? Mm-hmm. And then locate another physician for that patient. That's the continuum of care that we talked about. We want to make sure we have continuum of care.
Okay.
And then, or just say, look, here's some other doctors in the field you can contact. And then transfer all medical records when they get a valid release from the new provider. And then close it out lastly, assure that they have adequate refills of their medications.
So what is there any threshold that you all can think of practically, other than obviously if someone is in dire health straits, where if you terminate their patient relationship somehow, it's like some component of abandonment by the physician. Where does that turn into? I have the ability to legally terminate my patient relationship with you versus I can't terminate it right now because it would be deemed abandonment, if you can imagine.
I think it would deal with the
just acute care scenario where someone
where someone it's sort of like a legal case. In other words, if you get so far in a case and trials pending, and you tell the judge I have to withdraw from the case, the likelihood of the judge telling you that is very small.
That's what I was
similar situation with a doctor. If you have been treating this patient in sort of an acute setting, or there's a time issue or time variant to a treatment plan that requires that kind of intervention by the provider, right? Then I think it would not be looked. I think the board might have a problem, with the termination event in that situation.
Mm-hmm. Yeah, I think, like you said, timing is everything. It's
facts
case by
and circumstances,
case,
right?
Making sure that you're not terminating them, and they had a very important appointment on the books in a short period of time
because of it, right?
Could harm them medically,
transition or replace, or
how about this?
You refuse to write a script.
How about a cancer patient who was coming in for their follow-up PET scan, and they have to get it every 6 months, right? Per protocol, right?
Sure.
And suddenly that doctor, whatever it is, says, I'm not seeing you. Maybe it's a radiation oncologist or you're an oncologist. I'm not going to do it anymore. And then you go to another doctor, whoever they recommend, and they say, I can't see you for another 4 or 5 months.
Yeah, I think that's a problem.
That's a problem.
That's a problem.
And if he was that doctor who's terminating was my client, I would tell him, you can't do that.
Right.
You have to at least get him in for the scan, do the scan, and then make sure that you can get him involved so he doesn't miss the protocol.
Sure. I think, like I said,
that'd be a huge problem.
That would be a problem. I think that's an abandonment.
Yes.
You're harming the patient. You could be harming the patient if their condition's getting worse.
You can't wave a letter at that point and say, I terminate him. No.
Right. In that diagnostic hiatus, something pops up, and then they come back, and you're like, oh, you missed it, right? And then that obviously is, you certainly wouldn't want that for the patient, but it's a potential liability for the physician.
What are your thoughts on terminating a patient for, if they're not paying copays at the time of service and they get behind copays or deductibles? What are your thoughts on that? Do you set a threshold of, if we, I know a lot of practices, as opposed to like taking a card at the counter, they bill you. And that's popular, I know, in a lot of pediatric practices, because you're in and out with your kids, and like it's your kid's sick and they just don't have time to do it.
I want to go to those practices because mine doesn't do that. I mean, I'm got to pay up front.
Well, what are your thoughts on discharging for financial reasons?
Tough call.
I would imagine that invokes a couple of different things. One, from an ethical standpoint, the Hippocratic Oath and everything. I think a lot of physicians take that very seriously, and we're very glad they do. and may be reluctant to. They feel like it's their calling, their duty, and they would like to get the copay, but they probably aren't going to. If they feel you can't, and it's actually an economic hardship,
Sure.
I would imagine in that scenario,
You can waive it.
It's
You have to
physician by
document
physician.
why, though. You have to document. Well,
Yeah.
Medicaid, you have to document
Let's assume.
why.
Let's
You get in
assume.
trouble if you don't take them.
That's
so like you
correct.
kind of
Yeah.
Especially if you're in network. I mean, if you're in network under an in-network agreement
Yeah.
and you don't take them, that could be a problem.
And so what I was kind of going to, and y'all are stealing my thunder, but that's
Sorry.
okay because we're all a team here.
That's right.
But so you see where I'm going, though. That's how,
Yes.
which I think is positive.
It's a good thunder.
So, yeah, no, it is you're backed into ethically what you want to do versus what you're legally required to collect at the point of service. And those things, they kind of conflict. I think you would be looked at favorably if you didn't collect that, but depending on what your payer's doing in terms of evaluating your compliance with their payer agreement and or recoupment issue or whatever, it may not look favorable. So you try to get what you can.
Yeah, I mean,
It's not great legal advice, but I think it. That's the issue.
but if you did, I think that payers, right? Because I know you're very familiar with that. Both of you are. You've dealt with this. Payers look for systemic waiving of copays
versus
an isolated transaction.
And that's where I think you're probably going to be.
That's
fine.
going to be fine, right?
It's
right.
If you were doing it all the time, they're going to say.
But terminating a patient or saying we're canceling your next appointment if you don't get caught up on these copays that we've billed you for.
I don't know. What goes off in my brain is that legal, right? It may be good business.
Well, also,
because
is it in network or out of network? So I need more facts. So if you want to do in network, I think your in network agreement would obviously hold, right, George?
I think so. Yes, but
but what about out of network?
I
don't know. Tougher call.
Yeah.
It's a tougher call. I'd want to know facts and circumstances, and I'd want to know if it's chronic and willful, or if it's something. Bottom line is, I don't want to expose my client, the physician, to any legal action because they did this. And so off the cuff, I don't have a good answer for you, but I think we'd know where to get the answer to look at.
Interesting. We always have good topics.
Sure.
I mean,
and if it's on Friday, we'll meander a little bit.
That's another thing. I want to see. We got to get George in the studio more.
He has a good third voice to the podcast.
He does. He knows his stuff.
He's got a voice for radio.
Oh boy,
yes.
A face to match.
That's good. That's good. Well, I think here. Any final thoughts, gentlemen, on practice closing or terminating patients? Interesting one, Rory, about the dental board. I didn't know that.
Yeah,
that's good.
I think my big takeaway for closing a practice, selling a practice, terminating a relationship is that it's not going to be as fast as the client or the provider wants it to be.
It never is.
And there's going to be steps involved, and you just want to be done with it. You want to be done with the patient or the practice. But unfortunately, you need to follow guidance from whoever you get it from, because you don't want to fall into a trap a year or two down the road, or get a complaint against you, or not have a patient record, and then there becomes an issue with that.
George?
I think you've got to remember that the entity's your friend, and you want it to be around for a few years to take some flack for you, so to speak, and winding it down otherwise, I think you should view it as a wind down and not as a pull the plug, so to speak. In some of the examples that Rory cited, though, I mean, that's unfortunate, but people leave us sometimes, and it's unexpected, and so you've got to kind of deal with that in a more reactive scenario. What you hope for is that there are enough business processes in place to where the office manager, who has all the keys and the passwords and knows where everything is, can still provide the continuity of information necessary to transition the practice in a legal manner. Sometimes maybe that's not available, or if it's more of a sole practitioner with a little less sophistication, you could have some issues where you just don't know where stuff is, right? But I think nowadays, I think there's a bit more practice automation. A lot of things have software, and so hopefully the ability to transition those things, even in the most unfortunate of scenarios, is going to be mitigated.
Interesting. All right. Well, I think that's going to wrap it up here. I want to thank
Yeah, we went 20 minutes times 2.
I know, isn't that great? And with George Mueller, I mean, I'm happy. I'm so excited he's in the studio. This is great,
Got more hot air in here than the Hindenburg.
Well, that's going to wrap it up with us here, folks. Another very good episode of Health Law Talk here at Shahardy Sherman Williams. We hope that you got out of this as much as we did.
Very good.
Yes, sir. And look forward to another episode coming soon. Enjoy the weekend. Enjoy your time with family, and enjoy just life. Have a good day.
Thanks for listening to this episode of Health Law Talk, presented by Shahardy Sherman Williams. Please be sure to subscribe to our channel, make sure to give us that 5-star rating, and share with your friends. Shahardy Sherman Williams is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does this podcast establish an attorney-client relationship. Reference to any specific product or entity does not count as an endorsement or recommendation by Shahardy Sherman Williams. The views expressed by guests on the show are their own, and their appearance does not imply an endorsement of them or their entity that they represent. Remember, please consult an attorney for your specific legal issues.